Welcome back. It's Monday and time for Law 101. I'm Rob Levine from Rob Levine and Associates. So we've spent a lot of time on motor vehicle accidents. We thought we'd switch the type of injury or type of area of law under negligence that you might have to deal with. One of the categories is premises liability. So we're going to wrap two things together under premises liability: slip and fall cases and other types of injuries on someone's premises. What we've taught you so far, the definition of negligence, duty, breach, causation, and damages, still applies 100%. In a motor vehicle, we talked about showing the other driver was negligent. In a premises liability case, we're showing that the shop owner or the homeowner, the person who owns the premises, is responsible for your injuries. So let's talk about a slip and fall case. So you go to the supermarket and you're walking through the aisle and there's a spill on the floor. Let's say the spill is blue, so it's Tide and it's detergent and it's on the floor on a white surface. And you don't see it, you're walking with the shopping cart and you slip and fall and you break your leg. So that's a type of premises case. The analysis that we apply is the same thing, duty. So the owner of the store, the general manager acting on behalf of the owner, owes you a duty of care, right? So breach, did he act as the reasonable, prudent person under the ownership of somebody who's maintaining the property? Did he know or should he have known that there was a spill on the floor? So if the person walking in the aisle in front of you, 10 seconds before you got there, spilled the Tide, then the store wouldn't be responsible because they wouldn't have had time to find the spill and they wouldn't have had time to clean up the spill before you were injured. If someone knocked that bottle over maybe 20 minutes ago, then we would say they're responsible. They're responsible because they have to be going up and down through the aisles and doing inspections to make sure that the premises is safe for you to be able to shop. So there is a difference between Massachusetts and Rhode Island. So in Massachusetts, they created a shopkeepers rule. So what does the shopkeepers rule mean? So normally the burden of proof is on you. You have to prove that the defendant was negligent. In Massachusetts, the element of showing that they failed to clean the aisles up becomes the burden of proof of the defendant. The defendant has to show that he took the proper and necessary actions to make sure that his aisle was clean. What does that mean? He has to keep a log showing how often he checks the aisles and the aisles were clear. In Rhode Island, the burden remains on you. So through discovery, we ask questions. Who cleans the aisles? How often do they clean the aisles? Are they keeping a log? And we look to prove through their information, taking depositions of people who work in the store owner, the general manager, and that's how we prove our case. Another example is you're in a home and a cabinet falls off of the wall in the kitchen and the cabinet falls on you. So we actually had this case. So we had to prove that the landlord was negligent. When his worker installed the cabinet on the wall, he used regular screws into the wall into sheetrock. They weren't braced behind and it wasn't held properly. And it was put up 9 months before the cabinet fell. So it slowly worked loose over time and then fell on our client. So we were able to show through the records that the landlord had his maintenance person hang them. Through his deposition, he told us how he hung them. And it was clearly negligent because it wasn't done in a safe manner and our client was injured. So very similar principles, but just different types of areas of law. So I hope you like what you heard today on premises liability. If you like what you heard, remember to like, follow, and share. Have a great day. We'll see you next Monday.